couldn't get any bigger and more complicated, was the new CDC guidelines. And we should tell you, as of this morning, there are 4 federal lawsuits. Mark, you know more than that? We heard the 4th one was dropped this morning.
Nope, that's all I know.
So kind of interesting, because many of you have said, how in the world can the CDC do this? What authority do they have? How can they not even let us have a hearing? At least the governor's order let us take the tenant to court and say, prove to me that you qualify. Prove to me that you've exhausted all remedies. And that's an interesting problem with the CDC guidelines, is it doesn't require that. They just fill out a form, and there's no provision for a hearing or for any right for the landlord to now go in and really contest that. So we're really going to spend quite a bit of time today really talking about that. And so, Mark, you want to kind of give an overview of what the CDC order says?
Sure. And so I know a lot of people were probably on the line with NAA yesterday. Remember what you kind of learned there. It's always a disclaimer on those things. 1, the attorneys are from other states. 2, they give advice, which I think is good as a general overview of where you're going, but it misses, or it lacks, because of the position of teaching to 5,000 people at one time, the specifics a lot of the time, right? It's not necessarily the guidance, it's more theoretical, and we can discuss that as well. But I assume today a lot will be questions, and we're happy to kind of dig in through those. And Denise and I may not agree. It's just, that's the split on opinions of when you have a law that's written across the country. It's not necessarily clear, and it's not necessarily good. So the CDC came out with their order. It applies to everybody. This is not a CARES issue. This literally applies to every single rental property across the entire country. And it basically says you cannot evict somebody for non-payment of rent through the end of the year once the tenant gives you a declaration hitting 5 items. What is important, so based on the CARES, it was all about whether the property is a covered property. Now it turns to whether the person's a covered person. And all it says is they have to sign the declaration and give it to the landlord. Now think about that. It doesn't say that they actually have to meet those criteria. It just simply says you have to sign a declaration. So until we get more confirmation from the CDC, that means you don't challenge, you can't say, oh, well, you're going to make more than that, the $99,000. It doesn't, it just simply says you can sign it. The first question we've received, which I'll just hit it right off the bat, is, okay, can you challenge if the form is not there? I think there's an argument there. If facially, they send you an email and say, I'm protected by CDC. Yeah, I think you can challenge that. That doesn't meet it, because that's not even the CDC declaration. But if they fill out the form from the CDC, I think there's no legal means to address it. And I'll jump to Denise and have her answer, what the next kind of question we see, or at least what she sees is one of the hardest ones. I just want to mention before we go any further, the penalties are incredibly severe. Corporate penalties go up to potentially $500,000 and a year in jail. Individual ones, $100,000. Literally, this is not a law. We can kind of give our opinions today. It does not matter. You do not skirt the law on this. Follow it as clearly as you possibly can until it's struck down by a court or until it expires, is my 2 cents. So if Denise, you want to go?
Yeah. So one of the questions I had this morning, which is kind of an interesting thought, is, well, can I ask the tenant to provide me that documentation? And, it's interesting because nothing says that the parties can't have a conversation about it. It says that you can't move forward with any kind of eviction action. So can you ask them? And I think many of the attorneys are in the process, if they haven't done already, kind of creating kind of a questionnaire form. Yes, you probably can ask them. However, here's the problem. It has no teeth, right? If they go, kiss off, I'm not going to tell you. There's nothing you can do about it, which tenants we're talking about, the ones that have already been ghosting you, especially if you're a CARES property, they've been ghosting you for months. Then right now, at least as it stands right now, you can't. Now, interesting, last week, there were quite a strong discussion among Arizona judges about whether they could have a hearing on that, kind of like the governor's order. We can have what's called a motion to compel hearing. That was originally in the first version, and it's not in the version now, what we call best practices. So there's not really any guidance. Just know that that's probably going to be something different maybe in the next 2 weeks. But until that changes, there's nothing you can force. If they don't, you can't give them a non-compliance notice for not providing any of that information to you. So I'd just be careful. Can you ask them? Can you create a form? Yeah, but work with your attorney, because you want to make sure that it doesn't threaten something that you can't do. But we've heard a lot of questions. Can you still issue the non-payment of rent notice? Absolutely. Keep moving forward. And that's a business decision. Some companies we've heard are not going to even issue notices. And the reasoning behind that is that there's a concern that the on-site people may not understand that if you get that form, it's a huge red flag, kind of like if you have a bankruptcy that comes in, everything should be frozen right away. In our office, we have software, we turn the whole screen blood red, which means don't touch it, right? It's super dangerous, bad things can happen until a supervisor looks at it. So it's kind of that idea, you need that process. If you haven't had that before, somebody needs to create a process. If you don't have the process, be careful, because if you're giving out 5-day notices and you're proceeding, the attorneys are going to ask you, have you received this? And if you really did, but you told the lawyer no, you personally could be responsible for that $100,000 fine. You personally, the on-site person who sent over the file. So that's why we're saying be very, very careful. It's probably one of the most punitive laws we've ever seen, and it's intended to really punish people and scare you, much more teeth than cares. All right.
And that's something that should go to your corporate, obviously. I mean, across the board, we're advising clients differently because it's an operational decision how they want to proceed or if they do it all. But my suggestion is, if you do not have the ability to lock down and know that your managers understand, like having them check off they've all gone through some sort of training on this issue or doing other things, it is not worth the risk to send out a 5-day notice on that kind of situation where it's possible a temp was in over the weekend and got the CDC declaration and didn't update your system. So you have to have a lockdown mechanism to make sure that you avoid this issue, or it's not worth gambling on. I understand, guys, how bad the past couple months have been, and you don't want non-payment for the next 4 months as well. But in the grand scheme of things, it's better than spending time in jail. Let's be honest. It's the past, the CARES Act hurt a lot of businesses. Same with all the attorneys. I mean, obviously eviction filings were down. We understand it, but it's just not worth the risk reward. So you really have to, if you are going to be proceeding, make sure you have a lockdown procedure. Make sure every single person that's touching files, that receives documents from residents, can do that. Switching topics a bit on this, though, what is important to remember, you can do non-compliances, you can do immediates, unequivocally, there is no question. If you're doing it, their tenants advocates are going to argue you're doing it to avoid the non-payment issue. So make sure you have proper documentation that it's really a noise complaint and it's not just fluff coming out of the office. But if there's a real problem on property, you are absolutely allowed to proceed with those. Non-renewals are a bit different. Non-renewals are trickier. The CDC says you can't take eviction and any action to remove somebody for the non-payment of rent. Well, a non-renewal, if you serve it to them and they're current, obviously it's not relating to the non-payment of rent. If they're 6 months delinquent, though, and their lease just comes up and you serve a non-renewal, you're not pursuing the legal means for non-payment of rent, obviously, but your motivation possibly is because they're not paying rent. And the way the CDC order is maintained, there is a lot of risk there again. So you really have to discuss that with your attorney if it's worthwhile taking that risk, or potentially if that's going to fall under. Because I could see tenant advocates saying, hey, yeah, you're serving a non-renewal, but it is because of the non-payment of rent, and therefore you are covered by the CDC. And that's something that has to be done on a case-by-case basis.
And Mark and I had that conversation this morning, and you just need to know that different firms are going to disagree because it's gray. Our position's been a little bit different. We believe that if that's an additional breach, and remember, if they're in the middle of a lease, you can't do that. But if they're month to month, our position is a little bit different. We think absolutely that's an additional breach, and move forward. Just make sure that you're careful that it's not that you're doing it to everybody who's green or orange or 7 kids or 12 legs or whatever. So be careful, just like you always are. Remember, fair housing is important in this process too. I was sitting here and my phone just sent me a text from a client who said, hey, I'm watching, but I wanted to know, so maybe they don't know there's a chat function on the bottom, so please add the chat questions. But they wanted to know, so the tenant hasn't said anything to me. In fact, we went to the property, we know they're there because their stuff is there. We think they're out of town because nobody's seen them. Can we still file? Absolutely, you can file the eviction action, right? It's possible that there are tenants who are not going to make that claim. So remember, it's the tenant's obligation to bring forward the fact that they believe that they're protected by the CDC rule. They have to fill it out and they have to provide that to you. Just a note, remember the rule just passed last Friday. What we've seen on Tuesday, Wednesday, Thursday, and again this morning is that some of our very tenant friendly judges are having it at the court and continuing the case for a few days to get to email the tenant the form so that they can now fill it out, which would stop your ability to get the eviction judgment. Some of you have had the motions to compel already granted, and now the constable is supposed to be out. You've already won. You've already proven that they didn't meet the governor's guidelines. And now they pull forward the CDC. It still is just as valid at any point, at any process. And so up until the constable locks it out, and some constables are actually carrying the CDC form with them and handing it to the tenants and saying, before I lock you out, are you sure you don't want to fill this out and say that you're protected?
Yeah, we've actually been told that the constables have been directed to do that from the JPs, which means you can go literally through the process, you get your judgment, and when the writ is, ready to be executed, the tenant will just sign off on it because the constable gives them the form. You have to, as an industry, we have to be prepared for the fact non-payment of rents are intended to be stopped by the CDC. There's no games around it. You can get really far, but ultimately, even the writ has a very, very low chance of getting actually executed, which is truly remarkable. Again, this does not mean it's constitutional. It is being challenged in court. I think, honestly, a federal judge probably will strike it down, but until it does, you have to comply and assume that this is the law of the land. And so I think it's important to note as well there, we're in changing times right now. Like literally what you guys have all known for as long as you've each been in the industry, this is entirely different. I know your managers are regularly used to going through the process, you get a non-payment, you just go through it. You can't have that mindset anymore that just because you've made it so far that you're going to make it the rest of the way. But Denise brought up something I wanted to touch on as well, which is if everything is triggered, like I mentioned before, based on the person being covered and based on them giving the declaration. So I got a question earlier this week was, well, can you do abandonments? Yes. If you're able to do an abandonment, think about it. It's really intended where this person skipped in the middle of the night, they're not there. And part of that statute also says that they're not in communication with you. It's worded weird, but basically you haven't heard anything, which means they haven't given you the CDC declaration. So if it looks like they're gone, I think an abandonment is perfectly fine as opposed to having to jump through the hoops to go through a non-payment or rent eviction anyways. So that may help in certain cases, but always the triggering event, you can proceed until you get that CDC declaration. As soon as you do, flag it, stop, do not take any other action. It's just not worth the risk.
There's a question on the chat box that says, so it's renewal time, can we just not renew them? Like give them a new lease and just leave them month to month? The answer is absolutely, you can keep it month to month. In fact, we've got some clients that have decided that they're not going to sign any term leases for the time being, that until this whole issue gets resolved, probably until maybe next March or so, all the leases that they're signing are only going to be month to month leases. So that in the event that there's a problem early on, and many of you may have already seen this, we had a series of tenants that moved in March or April, and especially in the CARES property, and haven't paid a dime since they moved in. And so that's a business decision. It wouldn't be made probably at the on-site level. So talk to your supervisor, your regional, talk to your attorney, because there's some thought processes about why we do this and why we don't. And the other one is, can you increase their rent? The rule hasn't changed. Yes, you can increase their rent, but if they're not paying you current rent, they probably won't pay you the increased rent either. But yes, absolutely, you can do a rent increase.
Yeah, if you guys hadn't figured out a theme, it is contact corporate, contact your attorneys. It's a different game that we're playing now than we used to be playing. Do not make calls on site. And I know obviously a lot of on sites, bonuses are tied to rent collections and all of those things. I'm not saying that's changing in any respect, but corporate understands when occupancy is down or collections down, it's just a different world than it was previously. So be cognizant of that in terms of how you're handling your processes right now. I want to mention as well, even when there's the disagreement between myself and Denise as well on the non-renewal issue, you're potentially, even if you file an eviction on a non-renewal, you're probably going to get it through potentially. My concern with the CDC issue is the CDC is not going to care, and they're not going to intervene at the eviction stage. It'll be 6 months down the road when potentially the Department of Justice starts prosecuting those cases. So just because you send out the renewal and God doesn't immediately strike you down with lightning, doesn't mean the eviction's good to go. You still have that concern on the backside that you have a CDC issue, and that's what you got to be aware of, where the penalties and the jail time comes in. So that's what you got to be cognizant of. So be careful in setting those policies.
Yeah, and that's why you would check with your legal counsel, because I can tell you, just all philosophies were different. I mean, same thing. You guys we just survived CARES, and so the philosophy along the way with CARES, Kevin, I'm sorry, I have a puppy noise here in the corner. Sorry, but in CARES, the question was, well, did you still send out non-payment of rent notices? Did we modify them? You know, after that period was over, we had to give that special non-payment notice, was like a 530. Do we have to do that in the future? There's just a lot of questions, and that's why you stay tied into your attorney and your corporate office, because every corporate office, as you know, especially if you work for more than one company, kind of has a different philosophy. Now, I see Gloria says, well, rent subsidy and tax credit, you can't go month to month, and that's absolutely true. Remember, some of you may have projects like PRAC 202s or 101s or 911s. There's a whole bunch of different subsidy programs, and those will regulate whether or not you can do a lot of things, including Section 8. Section 8 doesn't like you to go month to month. And they, in fact, they make you use even special notices that have some special language. So whatever your project is, make sure that you're really aware of how that may change anything that we're telling you.
Yeah, I think a good thing to mention though, if there were ever a pitch, or if there's ever a time to be interested in Section 8, it's now. Just knowing that that money is coming, the larger portion of it, from the city or from whatever entity you're working with, as opposed to the tenant. Because you're not going to, I mean, even if the tenant's paying 150 out of 1,100 or whatever the exact amounts are, you're getting a good chunk of it. So you have to work through those, determine whether it is a non-payment issue. Potentially under Section 8, you can serve a non-renewal for cause on those things. So you'd have to work through the specifics on how that actually plays out and whether you're getting money and whether it's really a non-payment of rent issue.
And Mark, it was interesting, what we discovered during CARES is that the Section 8 tenants who couldn't pay, as soon as we notified Section 8 that there was a problem, they immediately contacted that person and reminded them, if you don't pay your portion, you will get kicked out of the program. If you're having financial issues, let us know and we can do an interim adjustment, but don't lose your ability to stay in that just because. And I see this question here now that says, can we still charge late fees? Yes, the CARES late fee moratorium was for a small period of time, right? Basically from March 28th to July 26th, which in our world basically meant, you know, April, May, June, and July. But yes, absolutely, you can still charge late fees. In fact, the CDC notice specifically says that.
Yeah, and to address something else from yesterday as well, I think some of the discussions during the NAA was if you had filed a case and then the tenant gives you the declaration, what happens to your case? They were proposing that it abates and stays similar to how a bankruptcy would, and they would just kick to January. I think theoretically, legally, that's fine. What's happened here in Maricopa, at least, the judges have come out with their best practices saying, no, the cases just get dismissed without prejudice, which means you don't get your judgment, which I think is correct. The case stops, but it's supposed to be dismissed, which means you then have to refile in January. What's of course interesting, because you already hear tenant advocates arguing how this avalanche of evictions is coming. I'm like, well, if you create the problem, if you stop evictions for 4 months, yes, they're going to start up again in January, unless you get rental assistance. I mean, truly, the answer to all of this, just give me my soapbox for a second. If you want to play these games with landlord-tenant matters, just pay people's rent. Stopping evictions for a 4-month stint doesn't answer or actually cure the problem. It just delays the existing problem we have. And having tenants that now owe like $9,000 instead of $2,000 doesn't help anybody. And so I will be curious to see long-term how this impacts companies in terms of their credit screening criteria. Do they not look at evictions the same way? Do they not look at bad debt from prior landlords? All of those things we won't know. I mean, it's going to be you guys that figure out how this has a lasting impact. I just think the idea of, you know, putting this off for 4 months, yes, it's unconstitutional. Yes, it's going to make a mess. And then in the short term, for you guys, it just makes it more work because you really got to be tracking those CDC declarations from the residents. So I am sympathetic. I understand we've taken on a ton more work as well. For us to do every single eviction, we're doing a ton more work just to make sure it's clean. Just like you guys are doing that much more work to make sure it's okay when it's filed as well. So we're all kind of in this together. It's not fun. We understand.
There's a message here from Patty that says, so what I understand is that we can still send 5 days in NSF notices even if we're not able to file. Now, let me tell you, there's two schools of thought. Some people believe that if they've given you the CDC notice, that you should not send your traditional 5-day demand. If you're going to send a demand, it should be something like a reminder to pay notice. Then the other school, right? The other school of thought is you can still send that non-payment of rent notice, but you can't do anything with it. And I can tell you, there's not a clear answer. And so go to your corporate office, because the corporate level is the one that's going to decide, do we modify that language? They're going to have a conversation with the very top people. They're going to decide the risk factors. And so check with your top leaders, and they'll talk to corporate counsel. On the NSF notice, if they've paid you with a bad check, can you send that? Yes, but remember, it's the same argument. Does your current NSF notice or your current 5-day notice have some language that some people believe might violate CDC? And I can tell it's our position that we're not concerned about the notice, but I know there's just as many of the lawyers that say there's not, say that there are. And that's why on the on-site level, please make sure that you're talking to the highest level person making that decision, because you don't want to be the person that issued the notice and now the CDC, if somebody said it was a violation, they're having that conversation. It's kind of like with the IRS. We just don't want to have a conversation with them at all, right? Just safer.
Yeah, and I'll go out on a ledge. I mean, my personal opinion, and what we're advising our clients is, if, like, imagine that tenant that comes in, they're the one obnoxious tenant that you have. We probably have more than one, but you have that one, they're the pain in the butt right off the bat. Day one comes, first of the month, you're not even considered late yet, and they come in and give you the CDC declaration. What we're talking about right now is whether you can serve a 5-day after that or not. Sure, I mean, you can argue legally one way or the other. Why would you possibly do that, though? You can, even if you could take the argument that legally it's not an action to evict them, you can't actually file the eviction. So you're sending a 5-day, but you can't do anything with it. So you're risking potentially 6 figures and some time in jail with no upside. So personally, we're just saying, don't do it. Like, once you get the declaration, stop. It's just not worth the risk for 4 months rent to play that game on your personal level, on the business level. So that's our 2 cents for it. Don't play the game.
And Mark, we agree with that. Once you get the CDC, that's a totally different thing. I think the question was, can you still send 5 days now? And once again, that was a little bit of difference of opinion. Some say yes and some say no. Remember, that's a corporate decision. But we all agree 100%. I think every lawyer in this field, once you get the CDC declaration, stop. Don't give any new notices. Don't give any new NSFs, unless it's a non-compliance for something else, parking wrong, noise, fights, dogs, whatever those other issues are.
Yeah, and for those, I think, especially if you have the time, or depending on how tight your company is run, other evictions you can have a process to have those reviewed by 2 people or however they want to set it up. I mean, there's just ways of doing things differently than they've been done in the past. So you have double checks, you have things, every person has to look at the electronic file to make sure you haven't gotten something from the resident. Just doing things differently to make sure, you're being overly cautious, which is, look, we're attorneys. It's all about CYA. We don't want to deal with it on the backside. You just want to be clean up front, which is it is all about compliance right now. And frankly, as unconstitutional as I truly think it is, it doesn't matter.
I just got another text. It's funny. I've got some clients that are on the call, and they're sending some private texts. And the question was, are we going to talk about assistive animals? Mark and I talked about that just for a second. We know that in January, hopefully everybody knows that the government sent out some new guidelines on assistive animals, and it's really actually pretty helpful. We hadn't seen one for a number of years, and it provides some pretty good guidance. And it actually, at the very end of it, it has a few pages that's the last summary, and you can actually send that to the tenants. And they're encouraging landlords, when a tenant's asking for an assistive animal, to send that to the tenant so the tenant understands the law just like you understand the law. And so I don't know if that's a big issue for anyone, but if you're not aware, there is this new memorandum, and you really need to read it and kind of dig down into it. I thought it was interesting that for years, we all know about the assistive pig, the assistive parrots, the assistive chickens, barnyard animals, we call them. It was nice for HUD to say, okay, generally speaking, you don't have to take a barnyard animal, very few exceptions, and here's kind of what those exceptions look like. So for a while, we weren't really sure, and they did a really good job of explaining the difference between a service animal and other assistive animals.
Yeah, and most of you guys, I mean, honestly, that came out in January. That's like a lifetime ago. That was pre-CARES. Probably forgot that even happened at this point. I don't think it really changed our analysis. We actually had something similar in terms of going through the processes. That is definitely something, I mean, it's a bit more critical now, I think, of random assistive animals like the pigs and everything else. But potentially, even then, if a doctor says the person needs this specific animal, you potentially have to allow it anyways. I was really disappointed by HUD's take on it, in terms of it didn't do what it should have. It literally should have given clear guidance, prohibited certain things, and it just never reached that level, which is unfortunate. I still think ultimately, if you've got a doctor's note, that's going to trump most legal arguments we can make as landlords if the doctor actually prescribes that person that animal.
Yeah, I thought the interesting thing is they finally touched on the internet letters, which is kind of cool. They finally said, look, the internet letter is kind of suspect, and by itself, maybe it might be an issue. It also said that when the tenant files a request, gives you a request, it doesn't really matter when the timing is, because we all know when it happens, right? You're in there fixing something and they come back, go, hey, this dog was barking or tried to bite me. And you're like, what dog? Look at the file. Hey, there's no dog. You give it 10-day notice and they go, haha, stop. I have an assistive animal. And it was interesting that this said the timing, while it might be suspect, it's not going to be the end of the conversation. It's not going to be the deciding factor. And I thought that was interesting. Let's see, I've got a question.
On that,
go ahead.
That Denise touched on is this online publications. You get the certifications, you get the badges, you've got photo IDs for the dog. And HUD did come out and basically say that that is suspect. You have right to question it, which we've always questioned those. I think they're finally more responding to the industry, which is if you go online and you get a certificate and it says the person, the dog is a service animal, that's really focusing on the dog more than focusing on the person's need for that dog. Usually it doesn't even reference the person, and it's signed by a chairman of a company. So we've been attacking those for years, and HUD basically just finally recognized you can attack those. What's coming up now, which is much more complex and much harder for landlords, is doctors online from other states signing off saying, yes, this person's my patient. Yes, this person needs protection. And I think that's the next thing that HUD needs to actually come out with and say, look, you actually have to, be in the same state. You have to actually treat the person for an extended period of time, all of those. But for the interim, when you have a doctor's note, that is the end all be all from my perspective.
So there's a question here that says, I have a question. This is Daniel. So if you want to open up your microphone, I don't understand your question. It says, I have a question about part C of the form, payment plans.
My question was too long to.
Are you talking about from the CDC declaration?
Yeah, so from the CDC declaration, it says that Part C, they have to check one or the other. I have tendered to landlord best effort partial payments that are as close to full rent as possible, or I have submitted to landlord a payment plan which outlines how I expect to pay future rent and repay delinquent rent. So they have to check one of these two things. If we had a client, for example, at the curve the other day that, where it's like we're about to evict them, they've been ghosting us for months, and all of a sudden we get a thing from a tenant advocate group that says, my client would like to pay $800 a month. Well, that is freaking fantastic. We would have been taking $800 a month this whole time. But so, they check one of these boxes and it's absolutely not true. We just have to suck it up.
Until there's clarification, absolutely. And I hate to say that. I understand how frustrating that is. The law just simply says they have to sign the declaration. It doesn't, and they can be guilty of perjury if that's not true. But again, think about the context of this is coming up. That is the CDC. It's the federal government, whether we like it or not. That to leave that decision and challenge it from a justice of the peace in Maricopa County, you're not going to get the protection you want. You're going to say, well, the JP told me it's okay. And the CDC is going to be like, who the hell is the JP? Like, the Department of Justice. They just don't care. It's a different game that you're playing at that point. Until the CDC or some other larger court, Supreme Court from Arizona, comes out and says, you have a right to challenge it, it's not worth the risk, because you have the actual order just simply says the tenant, to be protected, has to sign the declaration. It doesn't say each thing has to be true as it applies to the landlord.
And it's interesting, locally, the guidance we got last Friday was, you know what, if you believe they're lying, call the police. Wow, we all know in our properties how efficient that is right now, right?
Oh yeah, because
that was call the police. So
do something about it.
You need to know that we are actively, AMA and a lot of other groups, we are actively pushing that minimally we need to do due process for the landlords. We have the right to look at that. We have the right to the information. So you need to know we are actively pushing that, and we're hoping that they'll add that as a protection for the landlord. It just isn't there yet. So remember, this has only been just a few days just
Right.
like when the governor's order came out and just like when CARES came out, for the first couple of weeks, everybody had to kind of figure out what it looked like. And then as we were getting closer to the end, what does that mean? What kind of notice do I have to give? What does that process look like? If I have to turn over to collections, what is that process? That's just something we just don't know yet. We expect to know in another week or so. So I'm sure we'll have some more conversations like this. And of course, that's the joy of belonging to this magnificent group, is that we are all on board and we all have our finger on the pulse, finding exactly what's happening. And that's really why we do this, to find out as of today, September 11th, 2020, what's happening today, because we know this afternoon or next Monday, it could completely change. And that's why we all do this.
Yeah, and Danielle, the strongest point also is, if you remember from the governor's order, the governor's order actually gives you directions on filing a motion to compel if there's something wrong in what the tenant's providing or there's insufficient documentation. The omission from that in the CDC order pretty much tells you don't have that right. Where one is giving it to you and the other doesn't, you have to assume that's dispositive of the issue until we get clarification.
But we can still contact the resident and say, you check this box, what's the payment plan? What are we doing? Let's do this, right? I mean, we can still.
Absolutely.
The CDC,
yeah, you can and you should. Yeah, you can and should.
Okay.
Yeah.
As long as we aren't sending them legal notices and sending them over to court, we can still attempt to receive payment.
I know you, Danielle, you'll badger them until the day's over, but as long as you don't start the legal process, we should be fine.
Guess what? Anyone who had a package no longer has a package until they got a payment plan.
I did not hear that.
You're joking.
I did not hear that.
I'm joking.
The Wexler has a question, and it said, so do we have to provide them with a copy of the CDC form? No, you do not. Some companies I know have been saying you do, and that's a business decision. The law doesn't say, the CDC form doesn't say all landlords shall provide this documentation. Just remember, if they say that, they're required to sign it, and every adult in the household is required to sign it. Hey, I think, Megan, you had a question. I saw your hand going like this.
I did, yes. I just wanted to interject. I am curious. So I know this is incredibly challenging. The CDC guidance is a struggle for most of us just because it is not coupled with rental assistance. So, I know that we're struggling with individuals that, have ghosted us for a while and are have disappeared and are now, coming out and having these protections. But I am curious from the AMA's perspective, if there is more advocacy happening around rental assistance and that being easier for folks to obtain, because I do have a heart for the fact that a lot of our clients are in just as equally of a shitty situation as we are, excuse my language, that they have lost their jobs or they've been reduced to 5 hours a week, or so it's also not necessarily on their backs that this situation is happening. And so that is, I think, where it needs to come from.
It's a great question. It's absolutely being pushed on a local level. The governor obviously came out with his $5 million fund, which is wholly inadequate, but at least it's a start. It's a drop in the bucket, but it's a drop. And it's being addressed on the national level as well. And that's why I mentioned it earlier. Rental assistance is the only answer at this point. Mm-hmm. This is taking a public issue of COVID and making it on the backs of landlords. Right. And that's kind of the pitch going on the national level. So absolutely, it's a concern. And there was a question there about, which I saw Danielle put and Denise answered as well. My 2 cents though, the question on that regarding the CDC orders does say all residents have to sign, period. Okay, but what does that mean? If you get a declaration and it's signed by one person, it's not signed by the other ones, are you going to go and try and evict half of the unit? We don't have that remedy in Arizona, right. Which means what can you do? You're probably stuck with it unless you want to risk proceeding forward and saying, no, they didn't all sign it, therefore I should be able to evict, but you can't do that in Arizona. So yes, the CDC orders it, but it's potentially a meaningless order because you can't do anything anyways, because that one resident is clearly protected, unless you take the position that the whole thing is void, which I think is a very risky proposition.
Hey, Megan, and on that, one of the things that you can do as a property manager is that if you could reach out to some of these assistance programs and let them know who you are. Reach out, just like we do with our police, and create a really good program and process with them, especially if you're in a particular city like Mesa. You know, Surprise, there are a lot of smaller programs, not City of Phoenix is a little bit harder, but there are a lot of smaller programs that once they know that they've worked with you once, a lot of your tenants may be off work or they're working from home. Do they have a scanner? Right? They have to get all this documentation. What you can do is say, look, I can help you. We want to anyway, it's because the money's coming to you. I can help. If you're having a program, bring me this information, even if your office isn't open. You can figure out a way for them to drop it off, set it down on the ground, you open the door, you come out and get it. But you can scan that and you can reach out directly. And by doing that, what we have found, especially even before the CDC rule, we have created this relationship with a lot of those agencies. And so when they say, oh, I applied, here's my proof, I applied last June, I'm thinking, what's missing? You're not giving them what they need because it shouldn't have taken more than 60 days or so. So we're able to contact them directly because we now know the file number and say, hey, Bob Smith said he filed, is there something you're missing? Yeah, well, we sent you guys this form. Well, we never got the form. Could you send it again? We'll file it today. Because, you know, those forms came in, maybe early on, you weren't as encouraged, motivated to actually sign that form because you knew it was going to take a long time to get the money. Well, now, why wouldn't you, right? We know it's going to take a while, but it's guaranteed funds, and they upped that money to $4,500 per tenant. So we still have about $45 million. I think, right, maybe 47 million that hasn't been dispersed yet. That's a lot of money. And I think if landlord, anything you can do to help connect all of that and put it together would be fabulous.
Yeah, we've done a lot of that work, and we're in Tucson. So, I mean, there is a lot of programs out there, and I agree with you. I think especially for more formalized landlords, that is a huge asset that's out there, that they can help to get the residents actually enrolled in these programs and moving it forward. So that's great advice.
And I think the better part, I mean, the good thing about the governor side as opposed to the tenant assistance ones was the governor side allows you guys to apply. It's just unfortunate that that is the drop in the bucket as compared to the larger amount that started over the 100 million, which is the residents had to apply. It should always, even when we were talking to the governor's office back in the day before his program rolled out, was, look, if a landlord goes and get an eviction judgment against the tenant, they should be able to take that judgment and just hand it in and get paid on that judgment. So the tenant doesn't get evicted, the landlord gets the money, and everybody's happy. But that's not how they set it up originally with the state, which is the problem. And it really should be more landlord driven. You can't have tenants being prevented from evictions and then put it on those same tenants to go get the money because they've lost the incentive to actually take the action. If you leave the evictions there and just say, hey, tenants, go get the money, every tenant will run out, get the money from the state and give it to the landlord. You just can't remove the carrot and the stick at the same time, because it really deprives the landlords of their rights.
There's a question here that says, Ashley, it's not a silly question, by the way. It's really complicated. I can tell you probably in your world, if any of you have been doing this more than, say, 5 years, this has been the most challenging period of time, the last 6 months, because every day you're like, can I open the pool? Can I not open the pool? Do I have to sign a form? Can I open the gym? Can I not open the gym? Can they sue me because I didn't open the gym? You know, there's so many new rules that it's just shocking. And your staff, all of you are afraid about this virus too. So you're working on, you know, many of you working from home, you're working on shared jobs. It's complicated. But the question was, I'm kind of nervous. Can I still send out material breaches? Absolutely. Health and safety, non-compliance, immediates. Absolutely. We believe that the non-renewals, absolutely. Specifically, any major breach is not protected. The governor said it's not protected, and the CDC said it's not protected. So if they are doing drugs, if they're screaming and yelling and threatening you, whatever that is, absolutely move forward.
Yeah, and that's not just, I mean, when it says material, that's not just the immediates. That also covers your non-comps, unauthorized occupants, unauthorized animals, pets, noise, all of those kind of issues. Anything outside of the non-payment is not covered by the CDC. It does make me think, though, just for purely entertainment's sake, can you imagine if somebody just got in the industry in the past 6 months? They'd be like, oh my God, this industry is impossible. Be like, no, just hang on. It will eventually get better. It's not this complicated usually. I mean, hopefully, you know, things will get better come January. But I do expect as well, just so everybody's on the radar, it's not like things are just necessarily going to go back and immediately January 1st. We're gonna have to wait and see what happens then as well. And then also happens, you know, with Arizona voting in November. All of those things kind of affect our industry, obviously, because you can't open the newspaper right now without seeing an article about the big bad landlord and all that PR that goes along with it. And so I
The
think
good
AMA
news
does
is,
an excellent job of addressing that. And I think that's obviously on the forefront of everybody's mind right now is you guys are housing providers. That's it. You're literally not there to evict. I don't count how many times I've told people, landlords like do not enjoy doing evictions. It causes vacancy. It puts you back in your rents. It's not a good situation. And so we're just kind of working on that narrative and addressing it publicly so people start actually understanding that.
right. The good news is we think there'll be a lot more houses that are going to be for sale because you got a lot of those little mom and pop investors who have been kind of riding the wave and the rents have been going up and up and up. And all of a sudden now they're thinking, I don't want to even play in the game anymore. So if you're wanting to buy a house, the good news is there'll be larger inventory in the next few months. Any other questions?
I think we've silenced the crowd.
Ooh, that's scary.
All right,
You know,
Sarah.
we're lawyers. We can talk for hours and hours and hours. That's what we do.
All right. I think we're good for it. You guys, if you don't have any other questions, I think we'll cap it about a few minutes early.
Okay, thanks everybody. You guys have a terrific weekend.
Bye, guys.
Bye.